Welcome back. You're still watching Daybreak on this 12th day of November 2025, and it's now time to have our conversation of the hour. I want to introduce the panelists here in studio, starting with seniority, the former judge of the International Criminal Court, Joyce Aloch. Good morning.
Morning.
Good to see you here. Then we have chairperson of the Chartered Institute of Arbitrators Kenya, Professor Kenneth Mutuma. Good morning.
A very good morning, sir.
Then we have the Vice Chair, David Njoroge. Good morning.
Good morning, sir.
And Jacqueline Oihenya, former chairperson of the same institute. It's good to have you, all of you here, to talk about the questions of alternative dispute resolution and arbitration in Kenya. Perhaps I begin with you, Chair. And assuming that a Kenyan has just woken up and is hearing of this for the very first time, alternative dispute resolution, but also the question of arbitration, what are you talking about?
Well, I think a Kenyan will not be surprised. That's the first thing, because they employ this ADR, what you've referred to as alternative dispute resolution, almost every day, to the point that we now tend to use the acronym appropriate dispute resolution. So they do it when they're negotiating in their homes, on the marketplace. They do it when they are in the job and there's a conflict that's come up. They do it when in their governance institutions, different scenarios. So in the simplest terms, it's anything that is alternative to the formal judicial system. So everyone knows the courts, but more importantly, everyone experiences disputes even more frequently outside the courts. In fact, there's research that's been done and that puts the number of disputes being resolved outside the courts from anywhere between 75 to even a higher number like 90%. So a Kenyan will not be surprised. Probably the acronym might surprise them, but they will have engaged in ADR in different forms.
And Judge, perhaps because you've been on both fronts of the judicial processes up to perhaps the highest level when it comes to criminal matters, and now very involved in matters of mediation, how do the two worlds compare in our Kenyan context? How have we secured it in law?
I'll start by saying that after making orders for 44 years from the Kenya judiciary and the ICC, I'm now very happy to be listening as people talk. Because in mediation, mediators listen as people talk, and then we help them to find, they have the authorities on them to come up with a resolution that they can live with. So that's what I do. I listen and guide them, but mediators do not make any orders. That's the main big difference. We don't make orders. No, the decision to resolve the dispute belongs to the parties, but we guide them. Yeah, we guide them. It's very different from the court process, where right from the beginning, when you're in front of me, I look at you and are you telling me the truth or not? Yeah. And I make an order I make a decision whether you are guilty or not. That was criminal.
So in this other world, it's more facilitative. Very
facilitative. And you know, I cannot believe how I transited so quickly and so easily. I sometimes even forget that I used to make orders. But I remember way back when I was in the Kenya judiciary, when I established the family division, there were occasions when I would tell lawyers that, can you just leave me with your clients for a few minutes? Of course, at the beginning they wouldn't, but then later on they would. And when they left me with their clients in my chambers and they're out, what their clients would tell me was completely different from even what I'm reading on the file. So maybe that was that was part of mediation, but I didn't even know about anything about mediation. Yeah, but I'm in a completely different, I'm doing what is completely different from what as I told you, what I did for 44 years. Yeah.
So who will tell me about how this is secured in law? Whether it's the Constitution or the statutes that you have?
Yes, okay, thank you. I think I can take up that challenge.
And, well, first, in the Constitution, Article 159, 2C, judicial authority is exercised in Kenya, and the judiciary is encouraged to promote ADR. Yeah. And there are a number of mechanisms that are set out in that section. Many of, I think some of them have been mentioned: arbitration, mediation, and there's, they call it reconciliation, but there's conciliation, there's negotiation, and they say and others. So it is actually quite permissive. It's not exclusive or strict. So even when you are negotiating in the boardroom, if you're negotiating even in the classroom, and as you're going into court and say, let's see if we can find an amicable solution, that is all ADR. And ADR continues to evolve at a really high pace, depending on what context. When it comes to technology, when it comes to the environment, so most of the courts have a provision to have, and I'm talking about the courts of equal stature, to also incorporate ADR in their processes. So to more of the newer statutes also incorporate some form of ADR, and state corporations which have been established also tend to have a provision under the establishing statute to refer any disputes or claims to ADR first before they are taken to litigation or to court. Yes.
And still, as we establish the conversation, David, what makes one an arbitrator?
The art of being an arbitrator is a formal process. You have to be trained in the art. Arbitration is a formal setup on its own, whereby the Chartered Institute of Arbitrators is one of the premier institutions in terms of training. There are different pathways that you can take. There is the pathway of mediation, but specifically on arbitration, there is the introduction to ADR and arbitration that you start with. Then you get to module 1, 2, and 3. And all these are very formal processes that one is trained. And because arbitrator is basically a private judge that you're hiring to basically listen and determine to the disputes that are brought before them. So it is a formal training. The leading institution is the Chartered Institute of Arbitrators. There are other upskilling aspects in terms of the art. So you start as an associate, you become a member, then you become a fellow, then eventually you become a chartered arbitrator.
Okay. And do you need any pre-qualification before starting out with the modules?
Yes, it is highly advisable that at least you have a first degree. Then you can get into the formal training of arbitration. Yes.
How much of understanding should you have in law?
Not really, because as arbitrators, we have engineers, we have architects, we have both from the built industry, but mostly it is largely taken up by the lawyers, but it is not meant for the lawyers. It is meant for every other field, because alternative, when we say alternative, disputes basically arise out of human relations. And it is from the understanding that out of that human relations, our forefathers used to resolve disputes on their own. So anybody can be a dispute resolver. So the training of arbitration is basically to enhance those skills that we have as humans to arbitrate and to resolve disputes on our own. Yes.
In a perfect world, how long would it take you to get to the point of now being, you said, eventually a chartered arbitrator? A chartered arbitrator?
It's a journey, and it takes, because the programs we follow from the UK, which is our headquarters, and they have a calendar that is released for the year. So when you follow the pathways, it can take you up to about 2-3 years to get to that level.
Okay.
Yes.
Allow me to jump in there. Actually, some of the leading media personalities, I like the line of questioning. They have actually started on this journey. So, many of them are our members. I won't mention their names. and I'll say, because the media plays such a central role, I think most of us are aware of its the power of information, its public role as the fourth estate. But when you were asking Jackie about ADR and how it features, one important aspect that we often forget is this country, in many of its political moments, has turned to ADR mechanisms. So when you think about the handshake, the broad-based government, when you think about, what was it?
NADCO.
Yes, exactly, NADCO and Nusu Mkate and all of those things. Those are actually ADR mechanisms that are being employed in the political context, and coming up with solutions that the courts per se can come up with. So there's been decisions, and the decision, of course, doesn't carry favor with the different factions, and ADR steps in. So what a beautiful thing it would be if we see more and more media practitioners become arbitrators and even chartered arbitrators, and begin to use this dispute resolution skills for the public good.
Interesting. Quite a good invitation there. Talk to us about, because sometimes you'll find a matter going to court, usually on civil matters. You can help me if criminal also exists. And then there's a court-appointed mediator.
Yes.
Yeah.
What is that?
Okay, I'll start, but I think I would love the judge because she interfaces very well.
Yeah.
Yes, karibu sana.
Go right ahead, Judge.
Court-annexed mediation, it started when I was not here. I was at the ICC, but when it started, as I understand it, was a pilot project for 1 year. It did very well, and then it was formally made formal in the court. So court-annexed, there are mediators who are accredited by the court, and they're in the list of mediators. I think as we are sitting here, we are all court-annexed mediators.
Mediator number 5.
Amazing.
Court-annexed mediators, so
Yes.
that when matters are filed in court and the judges, the judge decides that this matter is probably suitable for mediation, then that order would have to be followed. Whether the parties, well, some people say that it's mediation by force, but when the judges scrutinize the file and say this one is suitable for mediation, so there's a list of accredited mediators, and the file is sent to one of them. And that goes on all the time. And other than that, I think there were some amendments so that if private mediations are conducted by these mediators or any other mediators, then it can be brought to court. The mediator can file an affidavit and bring it to court, and it's made an order of the court.
Yeah.
So the court has gone that far, has done really well in the area of mediation. But I'd like him to add.
I can add a few more things.
Yes.
Because yes, I've been with the process right from the beginning.
From the beginning, I wasn't here at the beginning. Yes.
So when the process, the program, it was a program, the pilot program started, we were about 20 of us.
20.
And there was a big dream to bring in an alternative way of resolving the disputes that were actually creating a huge backlog. And that was in 2016 when we launched. So we're almost 10 years into the program. I must say that the court really managed, the judiciary really managed this program very well. And we started in Nairobi, and we're able to have the pilot programs now devolve into the different high courts around the country, they're in the counties. I think we have done more than 50%, so there are mediators, court-annexed mediators and they are next to each of the courtrooms in the high court around the country. And they're resolving disputes. Family disputes have been very, very successful.
Right.
And also within the commercial dispute resolution for the mediators in that space. And there have been attempts to explore also with the ELC when in the lower subsidiary courts and also the high courts. And it has provided many, many Kenyans an opportunity to take their matter out of court, to have a court-annexed mediator who's already been trained through the process and accredited by the Mediation Accreditation Committee. And they're supposed to start and finish within 60 days. So they can bring it out of the normal court process. And they go before an accredited mediator. The mediator walks them through, they facilitate. And there are three outcomes. Some settle very quickly, and everybody goes home happy. Some settle a few matters, and they say, this one is a technical legal issue. We can take it to the court to determine on that question. And some of them just say, let us agree to disagree. But the key thing is that, you know, the court system is very adversarial. But mediation gives people an opportunity to ventilate. So even if they don't settle, the experience has been that the relationship at least are maintained in the process. Yes, yeah.
So most of these matters that will be taken to mediation even by the court are civil in nature?
Yes, and actually that's what I was going to add to. So I think the controversy, if I may call it that, when it comes to this, is the extent of the ambits of what you call the parties themselves owning the dispute resolution process. So as Jackie had mentioned, so the court annexed mediation has expanded, you know, from family context, domestic, succession disputes, moving on to the commercial context. I mean, the pilot study was such a great success, so it invited and sucked in now the commercial side. More recently, tax. And everyone knows the age-old rule. I mean, there are three things you don't escape. One of them is your taxes. So that has now taken center stage. And the Chief Justice, allow me to really salute her, has been the pioneer and really champion of this course, trying to expand this bracket. Where it gets a bit tricky is aspects that touch human rights issues, aspects that touch legality and criminal sanctions, penal sanctions, and the extent that this mediation and this party-owned process can have. Is a very famous case of Mohammed, the Republic, Mohammed Abdi, Republic versus Mohammed Abdi. It involved murder. It went through some kind of alternative dispute resolution process, and David will speak about the expanded ambit of this, which we use the more appropriate term is the alternative justice system. So it went through this customary norms, then it was the Somali ethnic group, and came up with a decision. It had stirred up a lot of debate, and that's where the debate is. Are there limits to where this can actually go? I think the Chief Justice has made it very clear within the rule of law that there are certain limits, you know, when you're dealing with sexual crimes, you know, a lot of human rights, serious violation issues. I think that is really now beyond the ambits. But there are other cases, and I very, very want to hear from my colleague David, where we may frown upon the outcome of the decision, but who are we to frown upon it when the parties themselves are very happy? Maybe David can add something to that question.
Yes, and as you do that, David, what if there's a court-annexed mediator doing his or her job, but unable to yield an outcome that is an agreement? What then follows?
Okay, thank you for that. In terms of mediation, it is a facilitative process. And it is not mandatory that once you are sent to mediation, you must settle. In fact, the idea is to go, try it out. If it works, well and good. If it doesn't, you come back to court. But what that helps, because when you bring these parties and they speak to one another, because what happens in court, the pleadings in court, the owner of the dispute cannot even relate to them, because we lawyers, when we take them, we turn them into a legal jargon and they cannot even understand them. But now this is an opportunity for the disputant to face each other and discuss the matter, the underlying issues in the dispute. And that is why you'll find many a times, if they will not fully agree, they will have a partial agreement. Once they have a partial agreement, they will agree on the issues that they have settled on, and then revert and identify the issues that have not been settled for the court to determine. But further to that, let me speak to the question of AJS, because alternative justice system is now an expanded bracket in terms of what alternatives can do to this, to the country. And I want to draw it from the Constitution. And we have a very transformative Constitution. When you talk of Article 1, that is people's autonomy. The sovereignty was given to the people. And even in the preamble, it talks about respect to our culture. When you go to talk to Article 10, it re-emphasizes the same and Article 11. Article 43 is the right to choose culture. Article 60 talks about community land and resolving of the dispute. So in 2020, there was a major paradigm shift in this country when the chair of the National Steering Committee on Implementation of AJS, Professor Joel Ngugi, launched the policy, the AJS policy. So we now have an AJS policy, and now all matters that are resolved outside, it is the umbrella body of alternative justice system. And basically, this is taking back the people taking their judicial right and their judicial authority to be able to resolve their disputes. Right. But they are still under the judiciary, because under Article 159(3), the judiciary still has the supervisory role in terms of ensuring that whatever is resolved out there. So in terms of the traditional mechanisms, in terms of all the formal mechanisms like the models in ADR, we ensure that in AJS that they are being resolved within the constitutional tenets. Yes.
And still attached to my earlier question, so let's assume the mediation process has yielded an outcome and parties have agreed and everyone is happy, like she said.
Yes.
But then there's someone who's supposed to make a compensation, they don't do it. What should happen?
I can speak to that.
Okay, go ahead.
Because that is really enforcement.
Yes.
And I think Judge mentioned about the rules, the mediation rules of 2020. And once they came into force, what happens is that if you're within the Court Annexed Mediation Program, you prepare a mediation settlement agreement.
Yeah.
The parties would sign off and say, yes, this is what we agreed upon, and that mediation settlement agreement is then going to be taken to the court, and the court will adopt it. And once it's adopted, it becomes an order and a decree of the court, and it can be enforced like any other judgment, regardless of whether it is at the High Court or whether it is at the subordinate courts. And I know even the Court of Appeal is also embracing, and they're coming up with their own rules as well. Yeah. So you could also enforce at that level. So the process leading to the judgment is different, but once you get the judgment, then you enforce it in the normal way.
Can a party appeal against?
No, you cannot appeal. You cannot appeal, because we say that you have agreed, you have exercised your agency, party autonomy. Yeah. So the courts tend to be very hesitant about setting aside or interfering is the right word, with the mediation settlement agreement.
Judge, you wanted to say something?
No, I just wanted to add that one of the main advantages of mediation, really, is that it's at two levels. A mediator will have both parties and their lawyers, or a mediator will have one party, private sessions. And in this is, I believe this is what really helps mediation. I mean, parties to resolve their disputes via mediation. Because during this private session, you have one party, the complainant, and his lawyer, or her lawyer. And she, you know, this is where they talk about their issues, their concerns, and half the time, people cry even during these private sessions. And then you finish with that, you say, I'm going to the other one, and whatever you hear from this private session, you don't repeat it unless you have the permission. So you have the other party also, and then after that, you bring them, the two of them together, and you can see that you're beginning to gain ground. They're beginning to gain ground. And I think this is a process in mediation that is not in any other. It's not in arbitration. It's not in any other process except mediation. And I think this is what helps people to resolve their disputes via mediation, through mediation.
Okay. David, as you come in, so court sessions happen in courts.
Yes.
Mediation sessions, where do they happen?
mediation sessions, when it started in 2016, the pilot project, it was highly advisable that it be within the court precincts. And this was from the understanding that this matter was in court. So these disputants, if you take them away from the court precincts, then they will not have much confidence. I remember like somewhere in Embu, where I am based, when they were sent without the court explaining the process, there was a lot of fight against it. And we proposed to them, then let the magistrate or the judicial officer invite the parties, explain to them the process so that they can know that it has the blessings of the court. And now it has caught up very well. But further to that, let me add to the question of enforcement. When you look at the SOJA reports over the years, you will find that mediation settlement agreements, they are very, very minimal that are contested. Why? They are self-executing because the parties have been involved. This is their decision. It is not the mediators. You know, in court gives a determination. But in mediation and in alternatives, it is the parties that are facilitated, especially in mediation, to come up with their resolution. So you'll find they are self-executing. In fact, I think the SOJA report of last year said that 98% of these settlement agreements are self-executing. So it is very rare circumstances that you'll find the need of even going back to court for enforcement, because it is their decision. They have agreed in a plan of enforcement and execution, and they live up to it.
Okay, so that's for court annexed mediation or mediators. What if I have a dispute with you or between my firm and your firm, and we want to go for alternative dispute resolution? How is that process like? Who decides, or even hiring who it is and where that session should be held?
Okay, that is, this is what we call agency. Party autonomy. So when we are together, we are actually negotiating. The time when we start thinking we've gotten to that impasse where we cannot solve this ourselves is when we start thinking about looking for judge or some other mediator. So it's good to find out the reputation of the mediators who are out there. If you don't have one readily, or neither of the parties is able to recommend a person, there's the list of court-annexed mediators. You can find it on the Kenya Law Report page, so you find out who is already accredited. Now, when you're looking for them, you're looking for them so that you can find somebody who has the capacity and the competence and the licensing, so that they're answerable to the court. But you can go to them privately. So the rules have now allowed for private mediation. And when you contact them, then the usual procedure is they've contacted judge, and then judge will tell them, you come, and we'll agree where. So you find a venue. They'll come and they will have a preliminary meeting and tell them, explain what mediation is all about, because most people don't really appreciate the nuances. And you just walk them through what is mediation, what to expect, so that you can prepare them, especially on the aspect of, I am not going to determine your matter. You are going to come up with the solution yourself. So they really need to understand that their agency, their autonomy, their power remains with them from the beginning of the process right up to the decision that they make. And you'll tell them, look, I know Judge mentioned about caucusing. I might call you aside and we have a session, and I might then go and have a session with your counterpart. It doesn't mean that I'm discussing your case or coming up with a formulation of how we're going to fix you, because that's usually the problem. We are just looking for ways and brainstorming for a solution, so that when we come back, we will discuss the options available to you, and then you choose. And this can all happen outside of the court process, but it is exactly the same. It is mirrored within the court-annexed mediation program. It is mirrored also in the private mediation setup. We've seen quite a bit of mediation, and it's really evolving and emerging in the workplace. So we are calling that boardroom engagement. But I can tell you, and because we have a new program that we want to do for mediation ministry within the religious process. So that is also categorized under private mediation. So the mediators who will come out and they're able to talk to you within the context of your faith will be able to help you, walk you with the process and get you to find a solution that works for you and works for you, you know, your culture, your beliefs, so that it becomes so customized to you that it really enables and facilitates those settlement agreements such that by the time you're coming and making your decision, you know, this is mine. The problem with the adversarial process, you're still, I'm happy I won you, but or I won the case, but I don't think you suffered enough. So that's the paradigm shift that mediation has brought into the process.
And mediation is a win-win situation.
Win-win.
Because the decision has come from the parties.
Okay.
Yeah.
Still on that question of venue, because when you said that if it's private mediation, you'll agree on the venue. So what is that? Does it include at a restaurant, or is it a virtual meeting?
You can do it anywhere. By the way, virtual mediation has also worked very well for Quarter-Next mediation. So when the parties come, they'll come and they will present themselves from different backgrounds. So if because I want to talk about the mediation ministry, if it is within the context of faith, you might want to do it in church, right? If it is in the context of workplace mediation, you might say, you know, we have a boardroom where you can come as the mediator, come to our institution, help us work through this problem, and then we will work it into our HR instruments. So you'll go there to that venue. If it is in court, some parties just want to be in court. But then if, you know, many of us in Kenya, we are very tech-able. You say, I'm in Busia, you're in Mombasa, we can do this thing virtually. And you will walk us there. You know, there's the protocol of how we do virtual mediation as well, to just make sure that the parties are comfortable with the process, to make sure that they both have access to internet, and that they have a stable internet or platform which they can work on. So we can actually do mediation pretty much anywhere.
Okay. Does anyone want to talk about the cost implication in some of these matters?
I know we focused a lot on mediation, but there is a principle that runs right across all these ADR mechanisms. It's ownership. So the parties are owning the process. And I'm building up to the question of cost, because ownership is about legitimacy. So if you go back again to our political context, you can have an external authority with a lot of power pronounce itself, and yet raise a lot of questions around legitimacy and so forth. So ownership answers legitimacy, and legitimacy itself answers the question of sustainability. So, you know, you talked a lot about enforcement, whether people are going to actually hold this thing and say it's theirs. If they don't own it, there are very, very high chances that they actually might repudiate what David was saying earlier. So even the question of cost is not an independent question, as you would go to other external actors and they tell you this as a cost. It's a question that incorporates the agency of the parties themselves. So they actually discuss, this is what we want, this is the outcome of what we want, and we are willing to pay this for it. Now, that is a relative discussion. Because I'm in the construction industry, so one of my hats that I wear is from the Architectural Association, and I'm an advocate. So in that world, and maybe what hasn't emerged here, there is an ADR mechanism called construction adjudication. And what the built environment practitioners have said is that we want something that's very fast, private, confidential, and we are willing to pay this. So you might look at the shillings and cents and say, wow, that's hefty. But they're thinking about their projects and saying, if my alternative is to go to court, I have a project, buyers are waiting to buy, you know, this number of units. I have obtained money from a financier, the interest is running. If this takes me 6 years in the courts, I'm going to be running out of business. But if I'm going to pay an adjudicator, an ADR specialist again, this amount of money may look very, very high, but in the overall scheme of things, it's very, very cheap. And that argument cascades across all the ADR mechanisms, whether it's mediation, and we spend a lot of time on mediation, whether it's arbitration, where in normal circumstances an arbitrator is meant to be so well trained that he should be able to finalize this decision in 6 months, in normal circumstances.
6 months.
Yeah. Or whether that's an adjudicator, where they are actually pressed for time. So they're anywhere from 81 days, 42 days, depending on the contract that is in display. Okay. Cost is a relative issue. And ADR is actually still going to be touted as a champion for costs, because in the overall scheme of things, you get your decision and it saves you much more than if you went through the public process.
It's a relative question. I'm just wondering, because in the practice of law,
yes,
there are rates, aren't there?
Yes, yes,
yes. In quantity surveying, there are rates.
Yes.
Architectural profession,
yes.
There are rates. So how do you settle on that? Because I would imagine that as a business, every business will have to do its cost-benefit analysis.
Yeah.
Is it predictable?
Yes, it is. So I can speak now from an institutional position.
Yeah.
And before actually my tenure, while she was still the chair, we sent out a clear scale, what the advocates would refer to as a remuneration scale. Yeah. So it's very, very clear. You can see there hourly rates. If you know you engage an arbitrator, this is what you're going to expect to pay for this number of hours. Yeah. But also ad valorem rates. Sometimes people may opt, we're going to go with the subject matter of the dispute, it's this amount, we're going to pay this percent. So these are two mechanisms that are used. Jackie can say maybe a few more things.
Let me speak to this, I think the first thing to say about cost is that any ADR mechanism is cost effective. And within the context of the actual charges, most ADR practitioners will charge on an hourly rate. So that is one option. And they charge an hourly rate depending on their expertise. So for mediators, it's mostly the number of years when since you started being in this space. And also whether you are a member of CIAB or whether you're a fellow. So if you have some you can demonstrate that you have some competence and that the qualifications also come with it. Yeah. So it tends to be willing buyer, willing seller. Okay. But in CIAB, we came up with a recommended guideline. Now, this is to be distinguished from what the lawyers have, because the lawyers have the scale, the advocate's remuneration order, that is actually by law. The guideline in CIAB is just the recommended industry rates. And so you find rates for those who have just come into the market starting from about 5,000 an hour, and then they graduate and they grow to the level of the chartered arbitrator, which is about 30,000 per hour. So what many...
Kenya shillings, yeah?
Kenya shillings, yes. Yeah.
We are in Kenya.
We have the dollar equivalence.
Okay.
Yes, but what tends to happen is that parties lose sight of the fact that if your counsel comes with many applications and they're technical, then you spend more time. And that time tends to add up and become quite expensive. So the guidelines are there to guide you, but then also the financial discipline also requires to come from the parties themselves. Prof mentioned something about the when we say ad valorem, it's really just a percentage of the dispute has come, it has come, and it has come for a big number, and we say we're going to take 2-3% of that, and we agree on that. Everything is still subject to the other taxation implications, and also if there are any venue costs. So that also, we call it arbitrators' fees and expenses. So there's a fees aspect, which is a professional service, and then there are the expenses. If you want me to come to your site in Turkana, then I'll have to find my way there, and how I get there is also going to be paid for by the parties.
Okay. Yes, judges of researchers, what do ADR practitioners?
Sorry?
I'm saying judges do have researchers or research teams working with them.
Judges do have?
Researchers.
Yeah.
Or research teams.
Yes.
Alternative dispute resolution practitioners, what do they have?
Can I help?
Please allow me to step
From
in
the
there.
SIAB headquarters. Let's hear that from the SIAB headquarters.
I was going to say on a cheeky note that we have AI, but I realized So Jackie, if you allow me just to speak on that. In every profession, it's a dispute. So you're making a decision. You will always have internally your team. And I know I started on a cheeky note, but all over the world, I think one thing that's being very accepted is the use of technology, because you would have to comb quite a huge amount of bundles. So the standard practice that entailed is you'd have assistants who would now comb what are these parties saying, what are they doing in support of that specific claim. How do they link causation issues, quantum issues to get what they're asking for. Today's world, and here we are speaking from international experience, today's world, technology enables all of that to be done at a very fast pace. So, but the problem is you don't lose your responsibility over the outcome of the decision. And I think you've seen some of the problems that come out where AI can actually lead you into a very, very dark hole. So you get a decision. Yes. So you can get a decision that doesn't exist and so forth.
Allow me to answer the question, Prof, because you are taking us in a different direction. Because you spoke about researchers.
It's okay, Prof.
On a light touch, we have this ongoing challenge about AI. I practice in AI, so I'm actually one of the bigger proponents. But when you speak of researchers in the judiciary, these are individuals who are supporting the court, and they help to do, the background work. They look at what the case is about, compile, and then finally give the judge something that is digestible. In arbitration, we tend to have mentees. And the mentees are the young and upcoming, the younger practitioners who have come up in the profession, and they want to learn on the job. Even lawyers have pupils. So learning on the job is actually one of the traditional ways of bringing up the younger generation. So we tend to take on a mentee. What the mentee does in the initial stages, they observe. But as you move along, you tell them, okay, now we've met the parties. You've heard what has happened in, say, the preliminary meeting. Can you prepare a draft order for direction number 1? Just talking about the calendar and everything. So when they do, they learn. So then they'll bring you a draft, and you come and you discuss with them and tell them, I would do this differently because of this reason. So we work with them. They assist us. They do give a lot of support, but they also are able to learn.
They attend most of these sessions.
They have to attend all the sessions so that they can become an arbitrator.
What is the security to confidentiality?
So when we have first, we don't allow mentees to come into the arbitration process or the mediation process unless and until the parties have agreed. So the parties' consent starts. They say, yes, you can bring in. Most times, they will not be... They don't object to it, because many of them have professionals who are also going through, and they also bring their pupils. What we have to do as arbitrators, and what I do, is to require my mentees to sign a confidentiality or non-disclosure agreement, so that yes, we're working together, so that you make sure that it doesn't go beyond us. You are part of the tribunal, because you also take responsibility for that person while they're with you.
And this is not subject to media coverage, is it?
In arbitration, we say that the people who are allowed to be in the room are those who the parties agree can be in the room. If they want the media there, yes. But if they don't, which most often they don't.
And that's the same with mediation.
Yes.
Only the people in the room must be approved by the parties. And I've had parties who could not even, a family matter, they could not even have the wives of the men who were in the room.
Look at that.
It's as confidential as that.
Okay. So let's talk about, because Kenya has been involved in major international contracts. I hope we can go there. And you find that in the contracting if a dispute arises, they appoint that the arbitration will happen in Singapore, or is it in London? How does that look for us, and what is Kenya doing to get to the point that arbitration can actually be done in Nairobi, not London?
Chair.
Yeah, Chair.
Yeah, okay. So this is what we essentially refer to as the attractiveness of your jurisdiction as a seat. And there are various ingredients, as it were, that make people want to come to Singapore, want to go to England, Hong Kong, and in this specific case, Kenya. So one, they look at the richness of your practitioners. So how many, sort of competent arbitrators do you have in that jurisdiction? Very pleasantly, I think Kenya really has, it's really top on the range when it comes to dispute resolvers right across the board. They also look at your judiciary. Because there is a relationship between the private dispute resolution process, like you heard from David, and enforcement issues, recognition issues. So does your judiciary understand what this is about? Do they have do they understand arbitration? Do they understand mediation? Again, Kenya is in the lead, and I gave a lot of kudos to the Chief Justice, because one of the projects that she has embarked on is to make sure that the judiciary, right from the top, are very, very schooled and top tier when it comes to arbitration. The Supreme Court, I think 6 or 7 members of the Supreme Court are actually fellows of the Chartered Institute of Arbitrators, and that has been cascading down to the Court of Appeal. What this means in practical terms, if a matter goes to be before the High Court, or even beyond the High Court to the Court of Appeal, you have, for an investor, an understanding that the judge knows this area of law, this area of procedure, and will come up with the right decisions. The other thing they look for, which Kenya, I think, has, is the independence of the judiciary. A lot of these disputes will involve an investor with our state or a state agency. So if the dispute escalates, a decision is made, that decision has to be enforced. Does your judiciary have the muscle to stand up? And I think you can see in a lot of African countries, this is a serious issue. Kenya, again, is really punching above its weight. We are measuring up to, your Singapore's, your UK's, in terms of the judiciary. Last but not least, of course, they will look at the general ecosystem of society and the way that ecosystem engenders that specific dispute resolution mechanisms. Here it's awareness issues. Do people know that they can actually go? There is something called mediation, and that they can turn to. Do people really know that there is something about arbitration? So that's about the user. And what is the user experience with those dispute resolution mechanisms? So I think Kenya is doing very well. In fact, speaking from the Chartered Institute of Arbitrators perspective, there is a very strong move to make this region the center of a lot of things that will be happening in Africa. And that's not just for the Chartered Institute. The same diplomatic move that you're seeing with the UN centering here on our country is happening with other bodies. Yes.
All right. I need us to take a look at the feedback that has come to us at Citizen TV Kenya. At Sam Gichuko, the hashtag to use is Citizen Daybreak on the comments. Babu Michael, the idea of ADR can be a great one if everyone is on the same page at the end of the mediation process. As has been stated, most of our political agreements, for example, are forms of ADR, but is everyone truly in agreement with the final outcomes? A good question. Remy Botia, the true frontier ADR is exploring is the shift from a justice system that is purely declarative, one that merely states who was right and who was wrong, to one that is generative, capable of creating new and workable futures for the people involved. Some Nyangu, some N Yangu, okay. You are saying I think we need an ADR to agree on the collection. In the ADR gospel, Professor Wine Kenneth Mutuma is the Pope. Oh, okay. We need to amplify ADR as an effective method of conflict resolution. This will free up our courts so they can focus on protecting our democracy and constitutionalism. Bob Otieno kindly asked Justice Aluoch, after mediation, if the culprit is found guilty, can the mediator send them to jail? Or can the evidence from the mediation be used in a court of law to imprison someone? Do you want to take that?
Yes.
Yes, go right ahead.
Mediation, as far as we are in this country, is still on civil matters.
Yeah.
We have not yet gone to start mediation on criminal matters. And mediation is without prejudice in the sense that, as a mediator, if the matter is not settled before me, I cannot be called to court to say what happened during the mediation. So once it fails to settle before me, parties are not able to settle, the matter goes to court, and that's the end of my responsibility.
So if there's an agreement, there's a settlement order, you called it?
A settlement agreement.
Settlement agreement.
If the parties reach a settlement, then there is a settlement agreement.
If they don't, what do you present to the court?
Well, if it's court annexed, we do a non-compliance.
Yeah, a non-compliance.
Okay.
Yeah, if it was court annexed. If it was private, that's it.
Okay, all right. The other question, what are the other feedbacks? Nixon Dugirem, to truly practice the process of dispute resolution and expect a fair outcome, you must completely abandon the goal of forcing people to do what you want and firmly reject any form of corruption from creeping into the ADR process. All right? Babu Michael again is saying, ADR is a good idea, but how can we make sure that parties aren't using it to evade justice? Example, the case in Tanzania, the president is now calling for an ADR form of reconciliation, whereas lives have been lost. How can we deal with such? Who wants to take that?
Actually, that argument has been prevalent, mostly for climate change disputes, and with the thought that if you have degraded the environment, then there's a polluter pays principle. But then and this is civil society, so when we are arguing about rights-based solutions, and this is a private process, there have been calls for transparency, at least on the international plane. What we say to this is, and I think we learned this when we all went to law school, it is better for parties to have a very bad agreement than to have a very good decision from court. Because that is another person who's coming to dictate into your situation what you should do for yourself. So because we have given the primacy of party autonomy, even in our constitution, we start that we. In fact, the first word in the preamble is we and I. So let us give people that agency and that opportunity. But if they cannot resolve, then we can ask them to go to a more open platform. But there's always going to be that tension, confidentiality versus transparency. And that is why we have courts, and that is why we have arbitrators. That's why we have mediation, so that the parties can actually choose the correct forum. So that ADR, yes, is alternative, it is appropriate, but really it is complementary to the judicial process. Okay,
all right. David, you have a conference next week?
Yes, we do have an ADR week, and as the Chartered Institute, we are basically offering a buffet of all the ADR aspects, starting from Monday to Friday. On Monday, we'll be having the domestic arbitration. On Tuesday, we'll be having international arbitration. On Wednesday, we'll be having the construction adjudication. And on Thursday, we'll be having mediation. And on Friday, the new baby in ADR will be having AJS, and also we'll be having our young members group conference. So we are inviting the public to come and sample what the long and breadth of ADR in this country is all about. We will be at the Kenya School of Government, and we are promising a week that will basically unleash and inform the public about ADR, all the mechanisms that are involved, where the country is, where the world is heading in terms of ADR.
Okay. All right. Thank you so much, David Njoroge, Vice Chair of the Chartered Institute of Arbitrators Kenya, Justice Joyce Aluoch, Certified International Mediator, and of course the former Judge of the ICC, Professor Kenneth Mutuma, Chair of the Institute, and Jacqueline Oihenya here, the former Chairperson. All the best next week, and of course the work that you continue to do. That's our time.
Thank you.
Thank you very much.
Thank you very much. I hope you will enroll very, very soon.
We'll have a conversation about that.
I hope Kenya will embrace.
Oh yes.
Yeah.
Oh yes. Okay. Up next is Safina Chengoma. She'll be here to talk about matters health and lifestyle. Let's hear what she has in store for us. My name is Sam Gitugu. See you again some other time. Bye for now.